Please, Your Lordship. Lordship, I'm mentioning a writ petition pertaining to land acquisition, Lordship.
Land acquisition means 5.
Daily list for motion, item number 5.
Page 21 is the tender notice.
Page 21 and page 23 is the condition, and page 26 is the continuation of the tender notice. That is the subplotting.
I have not understood. Firstly, 1 bigha is meant for lease.
Yes.
That is okay. Entire plot
Therefore,
that they want to settle on lease. But then why this page 26? Because
actually, Lordship, in the tender notice, they should have given this subplotting also.
because if the lessee
Yes.
is taking the entire market, whatever, on lease, then why this page 26?
Yes.
Subplot.
Yes, subplot.
Subplot means the bidders had to bid for subplot also.
Particular Lordship stop. Not for the entire.
What is the meaning of this?
Lordship, from what it appears from the petition, perhaps they are trying to allot subplots, my lord.
No,
From the map,
First,
in the page number
page
27,
21 is okay.
my lord.
The entire 1 bigha plot of land, they have panchayat authorities have been allotted.
Well.
They want to settle it on lease basis. And plot of land for Kharua Bandha daily market. That is okay.
My lord.
Then why this continuation notice? Subplot, please come to 26. In continuation of the tender notice so and so, it is for general information that the plot of land as indicated in the tender notice has been subplotted in block measuring 9 feet or whatever, 9 feet into 15 feet with serial number.
Well.
While submitting the tender, the plot may be indicated in the form. Now, this page 21 notice is for entire plot.
Well.
Right. Then how this plot number may be indicated? These are shops
My lord.
inside the market.
Yes, my lord.
So one for this, another set of bidding, another round of
No,
bidding.
my lord. My lord,
See, the concept is if you want the lessee want to have the market on lease, he will get entire market. Why he want to suppose he entire market plus one shop? Suppose he makes a mention in the bid for shop number 1. What would happen to other shops? No meaning can be culled out from this continuation notice. These are permanent structure.
No, Lordship.
No, my lord.
They have said it is a room, but they may also allow space for that particular land. That 9 into 15 foot.
Right?
maybe-
These are permanent structure or these are
No, permanent structure. Only the
temporary structure.
temporary structure. They will
So the lessee would give, he would collect fees.
When-
Then how bidders can participate? If you do not participate in tender notice page 21. I have not understood the meaning.
on that instruction, my lord, we need.
So don't finalize this part. Whatever, this lease page 21 is okay. But page 26, you
page
get the
21
instruction.
Page 21 instead should have been Lordship for that particular 34 stop, not for the entire one plot of 1 bigha land. They have described it as area 1 bigha more.
No, there is a market.
Here is the market.
21, suppose Panchayat authority, they want to settle as per Assam Panchayat Act. This is not as per Assam Panchayat Act. They want to settle the market. Then lessee gets the entire market. Then the traders, they set up temporary shops there. And the lessee collects toll.
Okay.
Per day, suppose 20 rupees from every trader. But here, this continuation notice has created the confusion. Because while submitting the tender, plot number may be indicated in the form.
Yeah.
Suppose lessee makes a bid for the entire market. Then he says, I only want to shop number 1 and 2. What would happen? This is creating confusion.
My lord, may I please, my lord. My lord, there is also another thing, my lord. The locus of the petitioners is also questionable.
They were there, but they are saying they were there. They have been evicted.
My lord, it's a
Government land.
My lord,
When they were doing business, it was basically a government land. Meaning thereby they were encroachers.
We are paying rupees 10 per day.
That you have annexed 1. But otherwise you are without permission, it is encroacher as per settlement rules. Then you have been evicted. Then that plot of land has been allotted to Panchayat. Then now they intend to set up something for which they has issued the tender notice for lease. To that extent, okay. But this page 26 is creating confusion. While submitting the tender, the plot number will be indicated in the form.
And these petitioners also, they want to bid for this particular one shop.
Yes, so if one shop, then it may not be necessary for one trader, small trader, to have all this turnover and all. This is against the normal concept of settlement. Yes. What do you say?
my lord, I agree with you.
That is difficult.
That instruction, my lord, maybe need.
Third, Mr. S.K. Das, Learned Counsel for the petitioners. And Mr.
U. Sharma on behalf of Mr. K. Kumar.
U. Sharma, Learned Counsel appearing for Mr. K. Kumar, Learned Senior Counsel, Panchayat and Rural Development Department for
Respondents 1 and 3.
1 and 3, G. Bokolia, Learned Counsel for Rural Junior Government Advocate Assam for the respond number 2 and 4. Full stop. Para. The petitioners. Comma, 9 in number, comma, have joined together to institute the requisition to challenge a tender notice dated 2/9/2020 and a notice and another notice dated 8/9/2023, comma, issued in continuation of the tender notice dated 2/9/2023. Post. Para. The petitioners have projected that they were earlier running their businesses from a government plot of land covered by Dag number 457, comma, situate at village Karawanda, comma, Mankasar Revenue Circle. Full stop. As the state government has allotted the state government plot of land in favor of the in favor of the South Halmara Mankasar Zila Porikhot, comma, and a process of eviction was undertaken under Rule 18 of the Settlement Rules, comma, framed under the Assam Land and Revenue Regulation 1886 by issuing an eviction notice dated 5/8/2023 by the respondent number 4. Full stop. It is projected that in view of the issuance of the eviction notices, comma, the petitioners had vacated their respective places from the state government of plot of land, full stop. After the eviction process, comma, the respondent number 3 has issued a tender notice the tender notice dated 2/9/2023 inviting sealed tenders from intending individuals, stroke cooperative societies, stroke farms, stroke companies, etc. for temporary lease of a plot of land measuring 1 biga, comma, covered by tag number 225/457 within bracket 01, comma, situate at Kharuabandha, which is a location of Kharuabandha Daily Bazaar. The petitioners have also challenged the terms and conditions of the settlement of the lease of the said plot of land at Kharuabandha Daily Market, contending that being petty traders, comma, they are not in a position to fulfill the eligibility criteria to submit a bid in response to the tender notice dated 2/9/2023. As the petitioner was of the view that even if after the settlement of the plot of land in favor of the successful bidder, comma, they would be in a position to carry out their business under the lessee with whom the said plot of land would be settled after the tender process. But in continuation of the tender notice dated 2/9/2023, comma, the notice dated 8/9/2023 has been issued, whereby it has been informed that the plot of land for which for which tenders have been invited, provide tender notice dated 2/9/2023, comma, has been subplotted in blocks measuring, so I have subplotted into 34 number of rooms, comma, each measuring 9 feet into 15 feet, base 26. And bidders responding to the tender notice dated 2/9/2023, have been asked to submit their tender indicating lot number in the tender form. As in view of the notice dated 8/9/2023, it is projected that in view of the notice dated 8/9/2023, subplotting the rooms in the market, the petitioners' livelihoods are likely to be affected as allotment of the shops, rooms in the located in the market are also going to be settled by the same tender process, right? Issue notice returnable in 4 weeks. As Mr. Sharma and so, Bokulia appeared accepted notice, no formal notice, extra copies. In view of the projections made in the aforestated manner, it is observed that till the returnable date, it is observed that the respondent panchayat authorities may proceed with the settlement process for release of the plot of land measuring 1 bigha in terms of the tender notice dated 2/9/2023. But no final decision shall be taken in respect of the allotment of the rooms subplotted by no final decision subplotted by notice dated 8/9/2023.
Okay, our bids may not be rejected for non-fulfillment of 3 and 3A.
Huh?
That of the our bids may not be
Rejected, I cannot say. Tender clauses. 1 bigha is okay. It is a big plot. You are not in the capacity to bid for it. You don't have the requisite income tax return also. But so far as subplotting is concerned, you want to trade there. So it should be kept open. That is what the intention.
There
Let
is
them-
another thing, my
Let the
lord.
instructions be received.
My lord, there is another thing, my lord. The eviction notice was issued to 9 persons. However, only 4 of them are among the petitioners. The rest of them are
You
not. in the-
controvert that.
No, all the 9s are there.
You
can see the
controvert
You can take the name.
in your affidavit.
My lord.
All the 9 names. are there.
Obligation.
Obliged.
Even one is enough.
Obligation.
Huh? Parhatu matter. Another thing.
Number 6 for admission, Parthad matter.
To discuss RM Chaudhary legacy number 6, interested me to pay for some time. Understand?
Legs. Okay.
For admission, item number 1.
It you partner or something? Yes. Yes.
Yes, in item number 1, I have filed affidavit, Lordship.
You have filed affidavit.
Yes, in the affidavit.
When? Today?
Yesterday I have given to him, today he is like,
Oh, it is not there.
it is not there. Lordship. Here,
Some other day.
Yes, sir. Because I have to also go. I have received the
You have received.
Yes, madam.
It is not with the court.
so they are taking time, Lordship.
9 ballot for date, madam.
Let us see what kind of short date we
They are
can
not
give.
in possession, my lord.
Lordship, there.
Who are in position?
Nobody possession,
Fact is
madam.
that, Lordship, I have gone to the, one file is also, we got one file also. where it is very clear that technical here they have cleared lordship. And here lordship, the fact is if there's a level playing field, if we consider level playing field also lordship, then also they will get lordship because they have put at 77 lakhs, they have put at 57 lakhs for 7 years.
And everything, if everything is vitiated by fraud,
Yes, lordship, earlier, lordship, here fraud is very much critical, typical lordship.
then fraud vitiates everything. Or irregularities, illegalities.
Lordship,
One man has the authority
lordship.
is issuing 2 orders.
Lordship, here, lordship, that is also my point to be said, lordship, that order, lordship. It is though that lady, that managing director is under suspension and he is facing lots of criminal cases also. Then also, lordship, in this peculiar case, lordship, he has issued the right order in the file, right order in the file. His signature is in the right order in the file. Only in the affidavit where no instruction was there to the learned counsel of that time. Only in the affidavit part there is another settlement order which is not instructed by then that suspended lady MD lordship. So she may be bearing in some other cases lordship. In this case, we find that he has rightly signed in the right order, but only in the affidavit part.
But from where that order
Yes,
annexed to the affidavit has
Yes.
emerged?
that part lordship, not from the record, no instruction from that lady also found lordship. That part lordship, I may request lordship that may create another problem also because lordship that part keeping that part aside lordship, only going to the record and keeping that part.
No,
lordship,
this is part of the record now.
Yes.
Is it not?
Lordship, it will create another. We will have to exercise another measure, many things lordship in that case.
Mr. H. Ali, petitioner, Bokoliel, Junior Government, Assam, respond number 1, 3, 4, 5, 6. P. Sharma, standing up, AFDC for respond number 2. And Mr. A.D. Chaudhary, and counsel for respond number 7. Post of Mr. Sharma, standing up, AFDC has submitted that he has an affidavit, additional affidavit, additional affidavit in opposition has been filed on behalf of the respondent number 2 in reference to the in reference to the order dated 12/9/2023. And as the said additional affidavit in opposition has not been tagged with a case record, he has paid for the listing of the case after review. But a date of another year.
Lordship, not it will not take that much.
No, question is finding out time.
It will not take that much time. But never matter comes to
Lordship already hard.
For you, it is okay.
You would lordship already hard many times. This matter,
Uh,
my lord.
10 marks.
10 months.
10.
My lord,
Hello.
10.
before,
Item number 2.
before,
Many matters are fixed in the meantime.
actually,
We're,
sir, my
we're
lord,
trying to find out,
nobody in
Mr.
possession, my
Ali,
lord,
Mr. Ali, trying to find out Tuesday. You want
Yes,
Friday
I-
or Monday? It is okay. I can fix any day. We don't know whether it will reach or not. Right.
We have
Nobody,
no
my lord,
actually
nobody in possession,
after-
my lord. That is the
Who is the partner at hearing?
But
Oh,
hearing for
oh.
no, 7 is here. Item number 7 for hearing.
Where is Mr. Bishwas?
His lordship
Huh?
is arguing on session court. He's having an argument on session court.
Yes.
He's appearing in session court. Lord. So
He has given preference to session court. Good enough.
Item number
I have heard him, so I am passing. Okay.
Seven.
এইটো হা এই কোন আছে বস্তুৰ মাটিটো এইটো কোনটো এইটো কোনটো দিছে বহুত কি দি আছে yes any standing council railway
My lord,
yes
I am for the BK Das, my lord. I am for the BK Das for item.
BK Das and who is the other one
My lord, Dr. B.N. Gogoi, my lord.
yes where is BN Gogoi
Yes,
Dr. BN Gogoi Mr. Mohanto, this 2012 to 12 repetitions will take some time, half an hour, 45 minutes. After that, because he was not there when the matter was called. Fishery matter.
I know, but actually my part is completed.
Anyway, his submissions have been recorded.
my lord, already heard, my lord.
Hmm. Hmm. এই কি কয় যিটো হেৰি এই যিটো নতুন সেইটো মই আপোনাক কৈ দিম একদম প্ৰথমতে লিখিব as both the both the repetitions involve similar nature of challenge. Command the same are taken up together at the request of the learned counsel for the parties, as they have stated that exchange of readings in both the repetitions is complete. Good. Instituted under Article 226. The petitioners, next para, the petitioners in both the repetitions the petitioner in both the repetitions is the petitioner in each of the two repetition is represented by Mr. M. Biswas, learned counsel, and the respondents in the repetition WBC number 266/2012 are represented by Dr. B.N. Gogoi, learned standing counsel, NF Railway, and the respondents in the repetition command WBC number 6103/2012 are represented by Mr. B.K. Das, learned additional standing counsel, NF Railway. As the nature of challenge in both the repetitions are similar, the facts and facts, pleadings, and issues involved in the writ petition, comma, WBC number 636103/2012 are discussed, comma, at first, comma, for the are discussed at first. তাৰপিছত এই যে ইয়াৰে 1 নম্বৰ পেৰাটো তাতে খালি ৰিনাম্বাৰিং হৈ যাব প্ৰথমৰ পৰা এইখিনি হা I have given due consideration to the arrival submissions made by the learned counsel for the parties and have also perused the materials brought on record by the learned counsel by the parties to their meetings. In view of the above rival contentions, comma, it is necessary to find out the nature of the contract, comma, that is contract number so and so, dated 27/7/2000. Date 2 about 2000. Oh, 2006 আগৰ ডিক্টেশ্যনবোৰত 2007 হৈছে হা contract agreement dated ha ওই তো ভুল দিছে ঠিক আছে ঠিক আছে ঠিক আছে ঠিক আছে 22/7/2000 entered into between the parties hearing in the acceptance letter process. In the acceptance letter, bearing number so and so dated 12/12/2006, comma, it was inter alia mentioned that the offer of the petition for the contract work was accepted by the competent authority for and on behalf of the President of India at a total cost of rupees 18,74,69,000. So stop. The contract agreement number so and so dated 27/2/2007 has been executed on 27 to 2007 between the President of India. Please take your seat. Mr. Gogoi is available or not? Dr. Gogoi, yes.
Yes.
Yeah.
I beg to apologize the type. My humble submission.
1 minute. 1 minute.
Yes.
1 minute. Please take your seat. I'll hear you.
I'm Mutlu.
I am dictating the other one. Mr. BK Das.
Ah.
So I'll hear you.
Yeah, sir.
You be here.
Yeah, I just
Between the President of India acting through the railway administration, comma, thereafter called the quote unquote railway on one part and the petitioner within bracket JV, comma, thereafter called the contractor quote unquote of the other part also. As per Constitution concern. As per clause within bracket 1 of Article 299 of the Constitution of India, comma, all contracts made in exercise of so and so. Article. The provisions of Article 299 of the Constitution of India require that a contract made in exercise of the executive power of the Union or of a state must satisfy three conditions, namely, PIJ. 1. It must be expressed to be made by the President or by the Governor of the state, comma, as the case may be, semicolon. 2. It must be executed on behalf of the President or the Governor, comma, as the case may be. And 3. Its execution must be by such person and in such manner as the President or the Governor may direct or authorize. Full stop. It is settled that failure to comply with these conditions nullifies the contract and renders it void and unenforceable. Full stop. It has been interpreted in a dissent so and so decision. It avoid. Stop. In so and so and in so and so, it has been held that Article 291 applies to a contract made in exercise of the executive power of the Union or the state, but not to a contract made in exercise of the statutory power. Full stop. There are two categories of contracts: the statutory contract and non-statutory contract. It is settled that even if a contract is entered into in exercise of an enabling power conferred by a statute, then also the contract does not become statutory contract if a contract incorporates certain terms and conditions in it which are statutory, then such a contract to that extent can be termed as statutory. A contract may contain certain other terms and conditions which are not statutory character and which have been incorporated as a result of mutual agreement, then such terms and conditions in the contract are to be treated as non-statutory in character. After surveying a number of precedents, the Honorable Supreme Court of India in so and so versus so and so has observed as so and so. Para. The present writ petition was filed on 3/12/2012 and was first moved on 17/12/2012. Was the affidavit in opposition. On behalf of the respondent, NF Railway Authorities was filed on 27/11/2013. It was eluded in the affidavit in opposition that the alias dispute was not eluded in that it was not eluded in the affidavit in opposition. That the alias dispute was referable to arbitration as per any arbitration clause contained in the contract agreement. It is only at the time of hearing the litigation he has been advanced that the dispute could be referred to arbitration. One has to be in mind that the contract agreement was executed between the parties on 27/2/2007. It is true that it is true that where the contract itself provides an effective alternative remedy by reference to arbitration, it is ordinarily a good ground for declining to exercise the extraordinary jurisdiction under Article 226 of the Constitution of India. It has been held in so and so versus so and so, reported in so and so, that a constitutional remedy iPad player Yes, you represent Bikeras.
My lord,
In the affidavit in opposition, is there any plea regarding arbitration?
there is no matter that they have not taken the ground for maintainability.
Hmm.
My lord. The earlier council is there. Here.
Okay. Okay.
in our affidavit, my lord, paragraph 8, my lord, yeah, stated. If,
is-
my lord, some, my lord, variation is detected, my lord, in
That is
contextual.
different. That I have not discussed it. That I have heard.
Fine.
Rambarai Singh, huh? Rambarai Singh. That a constitutional remedy by way of a writ petition is always available to an aggrieved party, and an arbitration clause in an agreement between the parties cannot ipso facto render a writ petition not maintained. It has been observed to the effect that availability of alternative remedy is definitely a permissible ground for refusal by writ court to exercise its jurisdiction in appropriate cases. Once the respondent had not objected to entertainment of the writ petition on the ground of availability of alternative remedy, the final judgment rendered on merits is not to be faulted with. Full stop. It is for the writ court to consider whether in an appropriate case, the writ petition should be relegated to avail the alternative remedy or not. Full stop. But once the writ petition is heard at length and decided against one or the other party on merits, such a decision, stroke order, cannot be held to be valid in law only on the ground that the writ petition was not maintainable due to availability of alternative remedy. In the case in hand, after the contract agreement was executed on 27/2/2007, the contract work was worked out, was completed on 31/1/2009. It was on and from 8/10/2010 when the final variation statement was issued by the respondent and applicable authorities, the dispute regarding vitiation arose between the parties. Full stop. The alleged dispute herein is alleged decision to recover a sum of rupees 25,21,881.27 by the respondent railway authorities on the ground that the contract agreement between them stood vitiated to that extent. Full stop. As to the maintainability of the writ petition, the Honorable Supreme Court of India in so and so and so and so after discussing previous judgments, has laid down the legal principles as follows. Para. Reverting back to the facts of the case in hand, it is noticed that the respondent railway authorities had first raised the issue of vitiation in the final variation statement prepared against the contract agreement dated 27/2/2007 on 8/12/2010. For ready reference, the contents of the said final variation statement are extracted here. Page 103. In the detail statement of calculation. Appended to the final variation state, it was mentioned that the contract agreement value was 18 crore 74 lakh 69,000. But the amount required to be paid to the contractor was 12 crore 86 lakh 54,568.71 paisa. The final variation statement had, does, reported the variation in amount within bracket minus sign rupees 58 lakh, no, rupees 58 lakh 81, sorry, 5 crore 88 lakh 14,431.29. And the percentage of variation as within bracket minus sign 31.37%. The final variation statement was followed by a letter seeking no claim certificate dated P1 2011. For a reference, page 100. In the letter dated 5/1/2011, letter number so dated 5/1/2011, page 111. And interdepartmental communication. It was inter alia canvassed that as the final variation amount had decreased to beyond minus within bracket minus 25% from the original contract value, vitiation has taken place, and the vitiated amount would be rupees 25 lakh 21,881.27. To arrive at the said vitiated amount, a comparison was made between the rates quoted by the petitioner and one Zoy Sand Lal Singhi, who was the L2 bidder in the tender process initiated by tender number so and so. It was after carrying out such calculation, a decision was seen to be taken to obtain a no claim certificate from the petitioner in respect of the appreciated amount. Para. As per the contentions advanced on behalf of the respondent railway authorities, Commander, source of power, the source of the right, source of the contractual right to recover the vitiated amount from the contractor is relatable to clause 6.0 of the additional special conditions of contract. Doctor. Para. The definition of the term vitiation has not been provided either in the contract agreement or in the additional special conditions of contract. Most of the respondents have not adverted to any definition provided elsewhere, which is part and parcel of the contract agreement dated 27/2/2007, executed between the parties. Full stop. In the affidavit in opposition, filed on 27/11/2013, a letter number is 156 dated 4/10/2010 of the Railway Board, Ministry of Railway, Government of India, has been annexed, and it is contended that it has been laid down therein that in case of vitiation of the tender, sanction of the competent authority as per single tender should be obtained. It is further contended that the provision for vitiation is not automatically applicable but the same is subject to sanction of the competent authority. Full stop. As such, the recovery of the appreciation amount is not debarred in any manner. Full stop. It is also canvassed by the Learned Council for the respondent railway authorities that as per the said letter dated 4/10/2010, as the letter has referred to another circular letter 55/1995 of the railway board, the same is also applicable in a contract of the nature of the case in hand. Full stop. It has been urged that the circular letter number so and so dated 55/95 has contained the methodology how the aspect of variation is to be worked out. It is not open for the petitioner as the contractor to deny the authority of the railway board, deny the authority of the railway to recover the amount to the extent the contract agreement has got initiated. On perusal of the letter number 55/1995, an idea about the aspect of variation is discernible in the circular letter dated 1995. Close stop. By producing a letter number bearing number W stroke T62 stroke CON stroke SSL stroke EMB stroke 2006 dated 28/8/2003 of the NF Railway of the construction organization, NF Railway, in the letter of the so and so, produced before the court by Mr. Das Learned additional so and so. It is sought to be explained that in simple terms, quote unquote, vitiation is a process when a contract awarded to a lower bidder within bracket L1 and during execution, if some variation in quantities are done in that contract, and this same excess variation quantities are compared with other bidders like like the second lowest bidder in bracket L2, comma the third lowest bidder within bracket L3, etc. It is after putting the same variation quantities with the rates of other bidders, comma if the total contract agreement amount value becomes less with respect to the lowest bidder within bracket L1, comma then the excess amount of lowest bidder is deducted from his final bill as the vitiation amount applicable. It will it is canvas that vitiation can take place both in case of increase or decrease in quantities, comma, during execution of the contract work. Full stop. It is further explained that vitiation in quantities implies that the lowest bidder within bracket L1 is no more L1 is 127 comma question. No more L1 with the increase or decrease in quantities in comparison to L2, and to wipe out the difference, comma, the vitiation amount is recovered from the lowest bidder L1, comma, so that the lowest bidder within bracket L1 remains the lowest bidder within bracket L1 in all situations. Thus, comma, it is clear that the amount of vitiation has been worked out in the case in hand on the basis of the internal circular, on the basis of the methodology contained in the internal circular letters of the Railway Board, Government of India, Ministry of Railways, Government of India. By applying the methodology to calculate the vitiated amount, comma, the respondent and railway authorities had arrived at the sum of rupees 25,21,881.27. From a look at those two internal circulars, comma, circular letter number so and so dated 5/5/1995 and circular letter number dated 4/10/2000. Comma, it does not appear that they are statutory in nature or they have been framed under any statute. So, stop. The concept of vitiation explained there may be relevant for the authorities in the respondent NF Railway, full stop. Since the two circular letters neither have any statutory force nor contain any statutory prescription, comma, the same would not automatically be made applicable to or govern the contract agreement dated 27/2/2007. Even it is assumed that the petitioner as the contractor had knowledge about the two internal circular letters containing the methodology of calculating the vitiation amount, the same would not be enough. For the respondent railway authorities to give effect to them unless they become part of the contract agreement governing the relationship between them. Full stop. It is in this connection, it is relevant to refer to the observations made in Bharat Sanchar Nigam Limited and another versus BPL Mobile Cellular Limited and others, comma, reported in 2008, 13 and 16, 597. Question. The core question involved therein is the effect of application of internal circulars issued by the Department of Telecommunication in the contracts entered into by and between the parties in respect of stroke as regards interconnection links provided by it. Full stop. the DOT authorities to charge their DOT authorities sought to charge the respondent hearing who obtained who obtained lease cycles by executing lease agreement on flat rate basis per party. Lease cycles by executing lease agreements. Full stop. It has been observed that the circular letters cannot ipso facto be given effect to unless they become part of the contract. Full stop. If the parties were ad item as regards terms of the contract, any change in the tariff could not have been made unilaterally. Full stop. Any innovation in a contract to be done on the same terms as are required for entering into a valid and concluded contract. As such, an exercise was not resorted to before seeking to change the tariff as indicated in the internal circulars, it was held that the tariff cannot be charged from the respondent on the basis of the internal circular in the absence of any agreement. As the lease agreement was non-statutory contract with no statutory rule governing the field, it has been observed that the parties with the liberty to enter into any contract containing such terms and conditions as regards the rate or the period stipulating such terms as the case may be. To stop. It has been observed that the matter might have been different. It has been observed that the matter might have been different if the parties had entered into an agreement with their eyes wide open that the circular later shall form part of the contract. Full stop. They might have also been held bound if they accepted the new rates or the periods either expressly or sub silencio. Full stop. It has been further observed that there are 10.7 or it has been further observed that the directions contained in the circular letters could be relevant for the officers who are authorized but the circular letters having no statutory force, they could not govern the contract. Full stop. If some authorities have violated the terms of the said circular letters, they might have committed misconduct, but when a contract is entered into, the parties shall be bound thereby. Full stop. The decision has also observed the following effect. Colon des is para 51. To put for a picture. As a higher rate was sought to be enforced on the basis of those internal circulars by the appellant BSNL, the challenge was negated. And the appeals preferred by the BSNL as appellant were dismissed. Full stop. Ten point eight. A even if, even a mere reference to those circular letters in the contract agreement dated so and so 27/2/2023 would not have the effect of making those internal circular letters parts of the contract agreement. First off, the reference to a document in the contract should be such should be such that should be such wherefrom the intention of the parties to incorporate the document in the contract into the contract as part and as its part and parcel is clearly visible. It requires a conscious acceptance of such a document as part and parcel of the contract by the parties, before such document could be read as a part of the contract between the parties. You know? It has been explained in it has been observed in MR Engineer and contractors within bracket B Limited versus Somdat Builders. Yeah, reported in 2009 7696 that এই তো, এই প্যারা। There is a difference between reference to another document in a contract and incorporation of another document in a contract, comma by reference. Full stop. In the first case, comma, the parties intend to adopt only specific portions or part of the referred document for the purposes of the contract. Full stop. In the second case, comma, the parties intend to incorporate the referred document in entirety, comma, into the contract. Full stop. Therefore, when there is a reference to a document in a contract, comma, the court has to consider whether a reference to the document is with the intention of incorporating the contents of the document in entirety into the contract, comma, or with the intention of adopting or borrowing specific portions of the said document for application to the contract. Full stop. It needs a reiteration that neither of the two situations is present in the case in hand, as the contract agreement number so and so dated so and so does not even contain a reference to the circular letters dated 5/5/95 and after 2010. 4/10/2010. Containing the methodology of calculating the appreciation amount, comma, as documents incorporated into the contract agreement by reference. Full stop. Fair. Para 11. It is as the contract agreement number so and so dated so and so is in the nature of a non-statutory contract and the interstate relationship between the parties are to be governed by the ordinary laws of contract, comma, a question also arises as to whether the action on the part of the state, that is state respondent, comma, that is the respondent in the railway authorities, in seeking to recover the sum of rupees 25 lakhs so and so as petition amount from the petitioner as the contractor can be brought within the ambit and purview of the power of judicial review as the respondent and railway authorities have sought, have projected that they have sought to enforce their contract enforce their right in terms of the contract agreement, enforce their right in terms of contract as the contract agreement in is contract agreement number so and so, so and so. It has already emerged from the discussion made above, comma, the methodology to calculate the appreciation amount is never a part of the contract agreement. Methodology and so contained in the two circular letters dated so and so, or in any other record, comma, is never a part of the contract agreement, comma, either by way of incorporation by reference or by any subsequent supplementary agreement. Does, comma, if such a methodology is to be a methodology of calculating the appreciation amount is to be treated and read as part of the contract agreement dated so and so, comma, there ought to have been a consensus between the parties who had executed the contract agreement number so and so at an earlier date on 27 to 2007. It is to settle a law that where a mode is prescribed for doing an act and there is no impediment in following that procedure, the performance of the act otherwise and in a manner which does not disclose any discernible principle which is reasonable, attracts the vice of arbitrariness. Full stop. Every state action must be informed by region, and it follows that an act uninformed by region is arbitrary. And in such situation, the principle enshrined in Article 14 of the Constitution of India comes to the fore, FORE. The basic requirement of Article 14 is fairness in action by the state and the principle of fairness in action does not permit the state to act otherwise in any field of its activity, irrespective of the nature of its functions, when it has the uppermost duty to be governed by the rule of law. It is also settled that non-arbitrariness Para- and having in regard to the fact situation obtaining in the case in hand, it is apt to refer to the decision of the Honorable Supreme Court of India, Kumari, Sri Lanka, Bitarti, and others, but the state of India and others, reported in 1991, 1 SSC 212, wherein it is held that applicability of Article 14 to all executive actions of the state being settled, and for the same reason, its applicability at the threshold to the making of a contract in exercise of the executive power being beyond dispute, the state it is held that after the contract is concluded, even after the contract is concluded, the state cannot cast off its personality and exercise unbridled power unfettered by the requirements of Article 14 in the sphere of contractual matters and claim to be governed therein only by the private law principles applicable to private individuals whose right flow only from the terms of the contract without anything more. It has been held, it has been categorically held that the person, it has been emphatically held that the personality of the state, requiring regulation of its conduct in all spheres by requirements of Article 14, does not undergo such a radical change after the making of a contract merely because some contractual rights accrue to the other party in addition. It has been held that it has been held that the Constitution does not envisage or permit unfairness or unreasonableness in state actions in any sphere of its activity, contrary to the professed ideals and exclusion of Article 14 in contractual matter has not been accepted. The decision in Sri Lanka Vidyarthi Sutra has gone on to observe as under 22, 23, 24. We're coming back. In view of the discussion made above and for the reasons assigned therein, this court is of the considered due that the action on the part of the respondent NF Railway Authority in seeking to recover the decision amount of this as per in terms of the final radiation statement dated 8/12/2010 is found to be arbitrary and unjust. Any amount is due.
Due to the contractor that they will calculate it. Then they will calculate, my lord, and they will pay, but they will not deduct this depreciation amount
If-
of 25 lakh 21,000.
If it is, it is according, it is therefore ordered that there shall not be any deduction. Sorry, ordered that the sum of rupees 25 lakh 21,881.27 as appreciated amount of the contract agreement number so and so dated so and so. No deduction of the sum of this so and so. Shall be made. In finalizing the use of the petitioner as the contractor. The repetition stands allowed to the extent indicated. There shall be no order to quote. Yes, Mr. Gogoi. Yes, so what is the second one?
My lord, in the second one, my lord, I have a personal difficulty in the sense, my lord, I have not been able to contact this petitioner for last 2-3 years, my lord. Neither
Oh.
he's contacted me, the
Now,
phone
what
number.
do you intend to do now? We have to close it. Either this way or that way.
My lord, what I pray before your lordship is this, my lord. That if your lordship post it after 2 weeks, I'll make a formal
No, no, no.
TT, I'll make a letter, I'll send a letter to her that I'm.
No, you could have done it much earlier. This is top of the list category. This hearing has started
No,
when? Right, Mr.? It started
No.
few weeks back.
It's not this, my lord, this is started, that was.
No, you cannot take the plea. This are taken up together, Mr.
Oh, in that case, my lord.
Mister, we have started it on 3rd of August. We are in September. Yes, Mr. Gogoi.
Lordship, I had filed an affidavit
Uh,
from NFLA. There is a stand of forest clearance certificate where they.
We are on vitiation amount, not on forest.
My
That is not the argued case. So argued case is to be, or whatever is pleaded,
Yes,
we'll decide that only.
I have filed an
Forest,
affidavit, Your
etc., we do not know.
Lordship. I
It
have,
is his, well, let us see his pair. Vitiation amount is 9,81,000.
Lordship.
What is
And-
the present status?
And we cannot issue the final claim because of that. I had filed my affidavit, Your Lordship.
The same principle will be applicable,
But he has already admitted
not admitted.
that she has admitted that she could not.
Where is that?
Let me take my affidavit, Your Lordship. 29/4/2013, Your Lordship. Affidavit by Pradip Kumar Das, NFLA,
Pradip Kumar.
Deputy Chief Engineer, Your Lordship. I had filed on first affidavit. There's a two affidavit whereby,
See,
yes,
Pradip Kumar Das, yes, which
Pradip-
date, which date?
26th day of April 2013. That affidavit.
Okay,
paragraph. First of all, the paragraph 5, Your Lordship.
Yes, then
Then, Your Lordship, paragraph 6, the amount which is to be recovered from the contractor. The bill is held up due to non-payment, paragraph 6, Your Lordship, page 3, due to non-payment of forest reality and not signing of no claim certificate, and bill is lying 2010. This is the amount, it is to be segregated, whereby it has to be recovered 16,70,838.
vitiation amount. What is the vitiation amount? That's all.
My lord will come to page number.
No, we are reading his affidavit.
Yes, Lordship. So, paragraph
Where is the vitiation statement?
Paragraph 8, Your Lordship, page 4. That is the statement. May I read, Your Lordship? Paragraph 8.
Yes.
To regard to the statement made in paragraph number 8, that deponent beg to state that the final variation of any individual item of the contract was duly got signed by the Punima Das, higher legal wife of the Jesse Das, which was finally sanctioned by the railway's competent authority. In the said variation statement, the vitiation amount was also been mentioned, and during sanctioning the final variation statement, it was advised by the competent authority to deduct the vitiated amount from the final bill. Deducted of variation amount from the contractor's final bill in the contract's condition which to be followed and acceptable to the contractor. Vitiation amount which have been occurred in course of execution of contract was duly been vetted by the finance and sanctioned by the competent authority, and is not unreasonable and discretionary power accessed by any authority beyond the railway contract.
Where is your acceptance?
Now, that is the
Acceptance.
Yes, yes, sir. I am page 18. Page 18, where she has addressed to the general manager construction
Where is that?
in that affidavit itself, Your Lordship.
18, page 18.
Yes, what she said. With due respect, may I read, Your Lordship?
Yes.
With due respect, I understand you the following you as follows.
Where is
My-
that? Page 18.
Yes,
Page 18.
That letter to address to the general manager construction.
Okay, with due respect, bold, yes.
That my-
Subject is prayer for waiver of vitiated amount.
Lordship,
Where is the,
paragraph 3, Lordship.
your statement is paragraph 8.
Lordship, paragraph 3.
1 minute. You're saying in the state variation statement, the vitiated amount also mentioned. Duly got the final variation,
Lord.
paragraph 8.
Lord.
Final variation of any individual item of the contract was duly got signed by Mrs. Punima Das,
Lordship,
heir wife of late Jesidas.
Lord.
Where is the sign?
Lordship, paragraph 3 of that
Three.
affidavit, that letter. That's as well as I expressed the inability to complete the work and requested to close the contract agreement, and accordingly, complete authority had closed the contract agreement without any liability or on either side. General Manager, Construction, Maligaon, so and so, dated on 2011-2009. So
Where is it?
there is in the next
She
paragraph,
asked for no liability from either side.
Lordship. Next paragraph. Final variation sanction date, General Manager so and so. It is seen that the work was done only 32.42% of the above contract agreement minus 67.58 less with the contract.
That is
agreement.
your unilateral act, the general manager construction. He has sanctioned his final variation statement. She said that final variation statement sanctioned
Lord.
by general manager.
My lord,
Then come to next 5.
Clause 5 would be.
It is learned that an amount of rupees will be deducted from my due of the above CA towards appreciation, which is not understood to me.
The above CA flows without any financial liabilities on either side.
Right. Where is the admission? And subject is prayer for waiver of waiver. It is maybe waiver of vitiated amount.
Lord.
Where is the admission? You cannot read the sentence and bring out a meaning which is not decipherable from that. Any other?
Yes.
It is not admission.
Necessary events. Now paragraph 13. My affidavit. This is a contract clause. Then paragraph 14 here.
Now, in view of what has been held by this court in the other repetition,
About 12.
same will happen.
But here in this case is completely different. One part is decision amount. Assuming this honorable court, whatever they decided by the earlier court is different.
Clause 6 is same.
So for the why it has been held out, it has been mentioned in the paragraph 15 of my railway affidavit. Non-submission of forest clearance certificate.
That is not, I'm not.
Non-signing, no claim.
Okay, you deduct that, whatever is.
Not signing
What
the
is,
final
what is challenge here? Let
But
us see what is the challenge here.
I'm only
Come to
concerned
page 9.
that to pay the outstanding bill amount of rupees such and such. That is the vitiation amount only which they have deducted. In fact, in response to an RTI reply, they have said
So
that
9 lakh 80, the petitioner is concerned with 9 lakh 81,000.
vitiation amount.
Not regarding terrorist royalty, whatever others.
But
it is the vitiation amount. Come to page 19.
No, I haven't seen it.
So why you decide about terrorist royalty? They are challenging only vitiation amount
Only.
only. The petitioner is not disputing your right to deduct forest royalty. Petitioner is disputing what is this vitiation. Please waive it. Page 18.
Lord.
Please waive it. Give me my dues or no liability from either side. Now, this particular amount,
Lord.
wherefrom it has emerged, let us see where
My lord,
you have demanded, they have demanded.
my lord,
They have demanded
Page 84.
84. This is in response to an RTI reply.
Amount as per final measurement amount payable comes to so and so. However, vitiation amount as per contract condition we divided is. So this you want to, so minus net payable is 51 lakh, 51,000.
Mhm.
Is it not?
And they want to deduct this vitiation. amount.
And in return, you have to pay 51,000. That is a core issue here.
the amount which
My lord, may I
Let-
simplify it
let-
further, my lord? Because my lord will kindly.
No, sir, I have done the simplification.
My lord.
Only the pages.
Page 83.
82 is a reply. There is
80
84,
83.
entry 18.
83. Question number 7. How the contract was determined, that is with or without liabilities. The contract was determined without liability. And
So
now they are-
ultimately, everything boils down to entry 80.
yes,
So this is the amount You made the final measurement, found out that the contractor can be paid 9,81,738.47.
Lordship,
Now you have worked out the vitiation amount.
Lord.
That is 10,33,671.48. So you deduct that amount, right? What is payable to the contractor and what is payable from the contractor, and reached a decision that contractor is liable to pay 51,933.01 to the railways. Is it not?
Lord.
Or anything else?
This is it.
No, no, Lordship.
I think this is it.
Lordship,
And whatever is there, whether first wife, second wife,
Those are my lord.
that is,
First- first wife, second wife, your statements are also contradictory. In any view of the matter, I have seen somewhere that this lady had got a succession certificate. So she has a locus too. She has some locus. You are disputing first wife, second wife. That entitlement is a different thing which should be which should be fought in a different forum.
yes, Lordship.
How do you justify this clause 6? Anywhere in the contract agreement that it has been incorporated by reference or has been made, all this circular, internal circular, which I have dealt with already,
Gotcha.
made part of this 5595, which was in existence prior to the contract agreement.
Good.
Whether you have brought it as part of the contract? No. Not an incorporation by reference like the new ones, some documents, that vitiation clause. Then you quote this particular circular. I have seen some
Yes.
last occasion that this circular is part of the contract. So they are bound by it. But here is again same thing.
Your Lordship, I had filed another additional affidavit.
Okay.
That is by on the 19, Your Lordship, by P. Bodoloi.
Hmm?
One another additional affidavit,
What new things?
yes, comes out, Your Lordship.
Saurabh Gupta,
No, his name is P. Bodoloi.
P. Bordoloi. 1 minute. So many affidavits. Why?
Because the contentions and my learned friend pushing it a vitiation in such an extent, and we department compelled to file 3 affidavits to satisfy before the honorable court as well as my learned friend also.
My satisfaction is immaterial.
So that is on 35 2019. If Lordship permit me to file one additional affidavit.
Huh?
One additional affidavit file.
One I have seen, Pradyut Kumar Das,
Pradit Kumar Das, then one PC Bodoloi.
PC Bordoloi.
All of the report.
1 minute. PC Bordoloi. Okay.
Is it there?
In white paper regime. Okay.
Okay.
Hmm.
Then paragraph 2.
2.
Yes. Then accordingly, Deputy Chief Engineer NFL Silsar, by this letter dated so and so, stated the claim 8 crores from railway, as made from time to time, is not tenable. Rather, JC Das has to deposit 15,82,000
Amount is increased now.
to railway. However, details calculation will be made as per the honorable decision. We leave it to the honorable.
Now, where is the vitiation amount? That's how he has dealt with vitiation. That is all.
Assuming your lordship, if 9 lakhs is to be deducted also, then he has to be ought to be paid.
No, we are into the writ petition which has questioned this 9 lakh something. That give me 9 lakh and waive the vitiation amount. That's all.
No, I cannot, my department cannot waive the decision only on the one point of view. So the another 2 things are have to be final bill. No claim certificate has to be issued, your lordship, in that part.
Mr. Gogoi, which I have dictated,
No, that I,
that vitiation amount is not to be deducted in the other writ petition. Whatever other liabilities are concerned, we are not concerned.
only one part. If lordship, I follow this first judgment by this honorable court, assuming the VCSN amount has not been mentioned in this the entire contract agreement. So this Honorable Court has pleased to satisfy that that cannot be ground for the VCSN as railway has failed to define the VCSN amount. Am I in the right track? Your Lordship? The
Right.
other part, which I suppose with my accumulated knowledge, the other was where the railway has withheld her amount.
You work out that.
So let me go for the agreement. You say there is an arbitration clause in the first tender we have mentioned in our affidavit. We had already mentioned the arbitration clause.
No, after 10 years, that is why I have referred to the judgment, Mr. Gogoi.
This is my first affidavit after
Right.
filing of this affidavit. Your
So,
Lordship.
so why did not raise it so many occasions?
I have told about my
You have
first
taken the
affidavit.
stand. Now it is not proper for the court also.
Now,
Are you ready to go for arbitration?
that
You
can
can
be
go for arbitration.
My lord,
for this part.
my only submission would be this, my lord, that as far as they are saying that because I have not submitted forest royalty clearance and I have not given NOC, and therefore my bills cannot be cleared.
Yes, sir.
My lord, if I fail on these two counts, my bill may not be cleared forever, my lord. I am not even agitating these two grounds before this court. My only limited point is whether the vitiation is justified. Let them withhold my bill for FRCC and other things. That would be different course of action. I may go for arbitration with my lord. I'm not at all on this FRCC and this, because I have made my client clear that FRCC will have to give under the terms of the contract.
What is FRCC?
Forest clearance certificate. If you take some forest goods during execution of a contract work, you'll have to get a forest clearance certificate from the concerned forest department. Whether after the lapse of 10 years, they might have given also the FRCC, I do not know, my lord, because
Okay, Your Lordship. It has been mentioned by the department, forest department, that there is a force document have been submitted before the department, Your Lordship. And I have annexed this.
Mr. Gogoi, come to the repetition. It is hardly of 7 pages. Come to the repetition.
Yes, Lordship.
Come to paragraph 1. Nothing is there to be discussed.
Lordship.
Then 2, about her condition. Nothing to be discussed.
Lordship.
Paragraph 3. It is about the contract work and the contract agreement, right?
Lordship.
Then paragraph 4. Total value of the contract. Not a disputed thing. Extended date of completion. Then this man died, husband died. Total value of the work to be done by the deceased contractor was 1 crore or whatever, 1 crore 5,66,000. And the actual payment made by them to the deceased contractor, which where from you are writing it?
my lord,
Mr.
these are based on instructions, my lord.
Uh, Let us see. Let us see paragraph 4, how it is dealt with. It is there, paragraph, page 3, paragraph 6 of the affidavit of Mr. Pradyut.
Lord.
Pradyut. Amount of total work done. Same figure. Less the amount paid. CC Roman 7 dated 33/2009. 95,000, 95 lakh, 84,676.
Lord.
Not in doubt. So 3, balance amount to be paid to the contractor is rupees 9,81,739. 4, less amount to be recovered from the contractor due to vitiation as per contract clause. 10,33,671, and net amount to be recovered from the contractor 51,932. Then add amount pending for FRCC 16,18,906. We are not concerned with that because he is not agitating it. Why should I go? Tell me. He is not disputing anything about that. Even after filing of this affidavit, the petitioner is not filing another affidavit, another petition. Why should I go into that? Tell me. Then come to paragraph 6. Paragraph 7, vitiated amount.
Lordship.
Paragraph 7 is vitiated amount.
Lord.
Then where is FRCC? No, nothing is in the FRCC.
This is
Why
there,
should we deal with that which is not the pleaded case of the petition?
Lordship, continuous. We have filed 3
No.
affidavits.
You work out whatever FRCC is there
Yes, it is there.
without insisting on vishisht.
Lordship,
Even if then also you will get something.
Let them recover from me.
it is there, Lordship, paragraph 15
What?
of my affidavit, paragraph 15. Lordship also little bit.
I have already, on the decision of the Supreme Court, even if arbitration clause is there, court is not precluded from exercising its jurisdiction. I have already passed observation on the basis of Supreme Court decision. When the action of the state in its executive capacity is ex specie arbitrary, such action is not to be, even in contractual field, that I have held. Nothing more. Only vitiation amount we are interfering with.
Only 15 years right now. Lordship has asked me whether there is any mention of forest clear royalty clear certificate. This is there.
Mr. Gogoi or Dr. Gogoi, what he is not disputing,
Now, only one point, if Lordship permit, only one technical point. If Lordship permit us to go not to deduct vitiation amount, that I admit whatever the law
that is all.
but so far the other party is concerned.
We are not even mentioning in the order. Why should we mention? You have calculated it in your affidavit that FRCC is 16,18,906. Did you file any affidavit in reply?
I filed an affidavit in reply.
Are you saying something on it?
Can we join the?
Otherwise, it will be precedent to other contractors, Your Lordship.
Which one?
If Lordship permit us a decision amount, I have nothing to say. The rest amount which has to be followed by some technical, some.
No, my lord,
issues are deeply
rather I have said in reply at para 5 that if you waive the vitiation amount, I'll furnish the forest clearance royalty certificate.
Paragraphs, come to page 6 of the rejoinder affidavit. That with regard to a statement made in so once the respondent waives the imposition of vitiation amount amounting to rupees so and so, then the petitioner shall settle the issue of forest clearance, forest royalty clearance certificate. Why you are arguing? She is not disputing it. Without going to just on the basis of your affidavit, you are arguing it. And which the court, I have said repeatedly, we are not entering into that field.
Lord.
You work out the contract amongst yourself.
Lord.
For heading to the WPC now, petition, WPC number 266/2000. One. Jiten Chandra Das. Page 13 huh? Pursuant to tender number stop CE stroke Halodia could work. One Jiten Chandra Das was awarded A contract work is welfare authority. Artwork is at an approximate contract value of rupees 3 crore 25 lakh 88,600. Full stop. Similar to the contract agreement number so and so dated so and so. I go to 27 to kiba asil na? A contract agreement being contract number is 11%. Dated 27/7/2006 was entered into on 27. Mr. Bisa, see the dates and facts.
Yes,
Okay. 27/7/2006 between the President of India acting through the Railway Administration, thereafter called the quote-unquote railway on one part, and Jiten Chandra Das, thereafter called the quote-unquote contractor of the other part. Full stop. Apart from the contract agreement, general conditions of contract, Roman 2, the specifications of the Northeast Frontier Railway 1998 edition, and 3, special conditions and special specifications, if any, and in conformity with the drawings, and the drawings were made part of the contract agreement, full stop. In addition, additional special conditions of contract were also made part of the contract agreement, and the additional special conditions of contract, contained the following clause, page 32, 6.0 and 6.1. Para. When the contract work awarded to Jiten Chandra Das by contract agreement number so and so was being executed, when he died,
13/6/2009.
Jiten Chandra Das, where is that date?
Page 3 of my petition, para 2.
expired on 13/6/2009, leaving the petitioner and three children who were minors at that point of time. Full stop. Para. It is not in dispute that after the demise of Jiten Chandra Das, the respondent railway authorities carried out final measurement in respect of the works executed by Jiten Chandra Das in relation to the contract work till his death. And as per the final measurement, comma, the amount payable was found out to be 1,66,415.47. Full stop. As an amount of rupees 95,84,676 had already been paid to Jiten Chandra Das on 30/3/2009 during his lifetime, the respondent NF Railway authorities found that the balance amount payable to Jiten Chandra Das as the contractor for the contract work was rupees 9,81,739.47.
38, my lord. 38.
38.
Page number 84.
Page number
84.
84. In affidavit,
So in affidavit, they've increased by 1 rupee. Probably they have
full
round-
stop. Para. After the respondent railway authorities, by taking resort to fixation clause, referred above, contained in the additional কিবা কৈছিলো না কলো না কলো এইটো additional special conditions of contract, calculated rupees 10,33,671.48 as vitiation amount. Full stop. The respondent railway authorities had further found out that and full stop. By in that manner, comma, the respondent railway authorities had worked out that net amount to be recovered from the contractor would be rupees 51,932.01. Full stop. The railway authorities had stated that railway authorities have also stated that an amount of rupees what is the full form of FRCC?
Forest Royalty Clearance Certificate.
An amount of rupees
Page number 3, last.
$16 lakh,
No.
18,000,
No.
906
Lordship,
is recoverable for issuance of forest royalty clearance certificate.
Lord.
Full stop.
My lord,
The
my lord. My lord has written for issuance of FRCC towards FRCC, because FRCC will be issued by the Forest Department.
towards FRCC. Full stop. The calculation worked out by the respondent railway authorities can be is also reflected in a letter bearing number page 103 dated 16/10/2012 of the Deputy Chief Engineer NF Railway. And the as under ইয়াতে এইটোৱে কৰি দিব। Though the petitioner has challenged in this petition, the petitioner has assailed the action on the part of the respondent NF Railway authorities to recover the amount of rupees 10,33,671.48 as petition amount, and has sought for a direction to the respondent railway authorities to disburse the amount of rupees 9,81,730. It is wrong, 39. They are repeatedly saying 39.
Their RTI reply, whatever may be.
39.47. Your document, 1 rupee more,
Yes, Lordship. Will always be more.
9,81,739.47. Insofar as the claim made by the respondent NF Railway authorities about the sum of rupees 16,18,906 is concerned, the petitioner in its rejoinder affidavit has mentioned that the petitioner would submit stroke settle the issue of forest royalty clearance certificate within bracket FRCC and sign the necessary no claim dues. Para. In view of such factual metrics, this court has found that as the insofar as as regards the fixation clause is concerned, the facts, the factual position of the case in hand is similar to the one in the writ petition WPC number so and so. Meaning thereby, the methodology the respondent NF Railway authorities have followed in working out the fixation amount of rupees 10,33,671.48 was not a part of the contract agreement number so and so dated 27/7/2006 either in any specific manner or by incorporation by reference. In view of in view of the as the factual matrices as the fact situation of the case in hand is similar to the one on the writ petition insofar as working out the fixation amount is concerned, this court has found that there is no reason the decision the regions assigned for declaring or for observing that the regions assigned that the act of act on the act of recovery, act of seeking recovery of the sufficient amount is arbitrary, irrational, and unjust. Is also found applicable proprietary vigore in the case in hand. Full stop. Therefore, in such view of matter, this writ petition, it is observed that the act on the action on the part of the respondent and applicable authorities in seeking to recover the sum of rupees 10,33,631.48 from the final bill amount of in relation to the contract agreement number so and so. Is not is not to be enforced, is not to be enforced. Full stop. Allowing the repetition to the extent indicated above, it is observed that the this court observes that repetition is allowed to the extent indicated above. Full stop. It is observed that this court has not made any observation as regards the claim of the respondent and railway authorities with regard to forest royalty clearance certificate.
My lord, only,
That is right.
my lord, only one thing, my lord. What is this? I want to know, my lord. Prior vigoria,
Proprietary vigore,
exactly applicable. That meaning,
applicable in all force, in full force.
in full vigor.
I will say in this nature. I will say in my discussion.
With full vigor, I got it. Vigor. That is that.
Proprietary vigore,
It is very
Something new I have learned.
meant, your lordship, to be
Something new.
applicable on all force, all force,
Yes.
FOURS, full force,
Full force. Vigor. With full
meaning
vigor.
by all four legs.
Okay.
Your lordship, I followed your lordship's judgments in not only in this case, other cases also.
1 o'clock. Okay.
The lordship wants us to read some one judgment. The lordship is indicating some judgment, my lord.
No.
Oh.
I have already referred, whatever. But you will not get it today because I'll be out Wednesday to 2022. Comma. 5 upper division assistants, including the petitioner and the respondent number 6, were asked to appear before an interview board as per the schedule indicated therein. Full stop. on the scheduled date fixed for oral interview stroke viva voce, comma, that is, comma, on 17/2/2022. The interview board constituted by the respondent number 5, comma, interviewed the candidates called by the notice dated 15/2/2022, including the petition and the respondent number 6, comma, to consider them for promotion to the post of supervisory assistant. Post of after the oral interview stroke viva voce, comma, the the order number 31 dated 3/3/2023 has been passed. Whereby the respondent number 6, comma, an upper division assistant, comma, then working in the office of Munsif number 1, comma, Dhubri, comma, has been promoted to, upper division assistant, comma, then working in the office of the respondent number 5, comma, has been promoted to the post of supervisory assistant, vice 1, Sri Iftikhar, IFTIKHAR, Iftikhar Azad, promoted stroke upgrade. Full stop. By the order number 31 dated 3/3/2022, comma, a number of other members of the Assam District and Session Judges Establishment within bracket Ministerial Service have also been promoted to different posts. Full stop. By the order dated 31, order number 31, dated 3/3/2022, comma, in the order, comma, it has been observed that the inter-se seniority of the respondent number 6 as supervisory assistant is to be counted in terms of his merit position in the interview above the petitioner, comma, also an upper division assistant. Better. by an order number 31 dated 26/5/2006, comma, a total of 11 number of candidates, including the petitioner and the respondent number 6, comma, came to be appointed as lower division assistant cum typist pursuant to a selection process full stop. The order number 31 dated 26/5/2006 further mentioned that the appointments were made in terms of a selection list published on 19/5/2006, page 1903, and communicated under memo number DJ point Roman 12/4 2005 2947 49 dated 19/5/2006. It further mentioned that all the 11 number of lower division assistant cum typist were appointed in the establishment of the district and session judge to agree.
10 numbers, not 11.
Okay, 10. Order. In the establishment of the district and session judge, comma, to be subject to the rules then extant, EXTAN, EXEA, and police verification. Full stop. It was stated, the order further stated that seniority of the above, the seniority of the said 10 appointees would be counted as per merit list, comma, if they join within 15 days from the date of receipt of the order. In the order number 31 dated 26/5/2006, comma, the name of the petitioner figured at serial number 5 and the name of the respondent number 6 figured at serial number 7, comma, meaning thereby, comma, the position of the petitioner was above the respondent number 6 in the select list, and at the time of their appointment on 26/5/2006. Para. The matters regulating recruitment and conditions of service of persons appointed to the Assam district and session judge, the conditions of service of the petitioner and the respondent number 6 are regulated and governed by the provisions of the Assam district and session judges establishment within bracket ministry Service rules, comma, 1987, page 27 of the Senate. Comma, framed in exercise of the powers conferred by the proviso to Article 309 of the Constitution of India. Full stop. The Assam the rules করে দিব আর in bracket, sorry, এনেকে লিখবো, the Assam district and sessions judges established within bracket ministerial service rules, comma 1987, within bracket the rules, comma 1987 or the 1987, and mention, regulate the matters of recruitment and conditions of service of persons appointed to the Assam district and session judges established within bracket ministerial service. As per rule 2.1, one bracket, comma, appointing authority means I love Rule 2 within bracket 3 has provided that quote unquote district and section is established means so and so and so. Quote unquote member of the service unquote, comma, as per rule 2.5 means a member of the Assam district and session judges established within bracket ministerial service and quote unquote service, comma, as per rule 2.10, comma, means the Assam district and session judges established within bracket ministerial service. Full stop. The post, the categories of post and the respective cadres are found mentioned in Rule 3 of the 1987 rules. Rule 3 has provided as under. Yes, 20. Though the post of supervisory assistant stroke Seristadar of Munsif comma, stroke, and upper division assistant are shown in the same category comma, it emerges from schedule dash Roman 2 schedule dash Roman 2, which is to be read, which is made relatable to rule 14, comma, though an incumbent in the post of supervisory assistant stroke Seristadar of Munsif stroke upper division assistant enjoy the same pay scale. I like it. Huh? a special pay is allowed to an incumbent holding the post of Seristadar of Munsif and supervisory assistant. Post of. Rule 14 of the 1987 rules has provided that the scale of pay admissible to members of different cadres are shown in Schedule 2, subject to such revision as may be made by the government from time to time. Full stop. Thus, it is evident that the post of supervisory assistant is higher in status than the upper division assistant, as a special pay is allowed to an incumbent holding the post of Seristadar. Post. Note, a note, the note below sub-rule 2 of Rule 6 has prescribed that for the purpose of promotion of supervisory assistant, which one is applicable? Okay. Okay. No, I don't know. The note, sub-rule 2. 3 of Rule 6 has prescribed that the post of Seristadar post of has entirely prescribed that the post of supervisory assistant is to be filled up by promotion from amongst the upper division assistants of the district and session judge, and session judge's establishment within bracket ministerial concern on the basis of seniority cum merit, who have rendered not less than 7 years of service in the district and session judge's establishment within bracket ministerial concern, out of which at least 3 years of 3 years shall be of continuous service as upper division assistant on the first day of the year in which the promotion is made. Itu note নহয় sub-rule 3 note to বাদিয়ক sub-rule 2 as prescribed. Right? The note appended to sub-rule 3 of Rule 6 has provided that for the purpose of promotion of the upper division assistant, the district and session judge shall prepare a select list at the beginning of each year, taking into account the number of vacancies likely to occur during the year in question. The district and session judge shall associate the additional district and session judge, assistant district and session judge, and munsif in the selection process. Full stop. It is reiterated in the note. It has been stipulated. No, the criteria for selection shall be on the basis of seniority cum merit, and the select list is to remain valid for 1 year from the date of recommendation of the selection board. Yeah. Rule 9 has provided for a gradation list, and it states that a gradation list of the staff of the amalgamated establishment is to be prepared every year, and the same shall be approved by the district and session judge concerned, and is to be published once a year. As regards the matter of seniority, in the cadre of upper division assistant, it is stipulated in sub rule within bracket Roman 2, small Roman, of rule 12, that in the upper division within bracket, including Saristadar of Munsif, bracket close, Kadar, comma, the seniority shall be according to the position in the select list from which the promotion to post of upper division is made. Para. In terms of rule 14, sorry, rule 9 of the rules, 1987, the respondent number 5 published a combined gradation list for the year in respect of grade Roman 3 and grade Roman 4 for the year of the incumbents in the district and sessions judge establishment Thubri for the year 2021. Full stop. The petitioner, the names of the petitioner and the respondent number 5, along with others, figured in the said gradation list. Full stop. for the purpose of the in view of the controversy involved herein, like the said combined gradation list has recorded the inter se seniority positions of the petitioner and the respondent number 6 in the following manner. Yate, page 25 or CL number 11 to senior number 11 to CL number 11 or 11 আৰু CL number 30 মই মিলাই দিছো কিতাপ ক'ত কৰিলে it is from the select list from the order dated order number 31 dated 26/5/2006 as well as from the combined gradation list prepared and approved, prepared under Rule 9 and approved by the respondent number 5 as the competent authority, for the year 2021. It has emerged that the seniority position of the petitioner was above at the time of initial appointment, above the respondent number 6, at the time of their initial appointments in a cadre of lower division assistant on 26/5/2006, as well as in the cadre of upper division assistant, as upper division assistant. It is also admitted in paragraph 4, 5, 6 of the affidavit in opposition filed by the respondent number 5 that in the gradation list of the staff published in the gradation of the staff of the office of the district and sessions judge establishment Dhuburi for the year 2000 21, comma. The respondent number 6, whose name had figured as serial number 13 of the daring, comma, is junior to the petitioner, comma, whose position has figured as serial number 11 of the gradation list. Goes. It is in the above facts and circumstances, comma, the validity of the order of promotion made in favor of the respondent number 6 to the post of supervisory assistant. Hide the order dated number 31 dated 3/3/2022 is to be considered. Para. Yes, these are the facts. Where is MS Sharma?
Page 25. Page 25, Lordship. Probably, Lordship, the district administration has taken the date of birth as a.
Okay. How?
That cannot be, Lordship. Otherwise,
Oh,
that cannot be.
see the because
I've seen.
because some submission is required because
Made position he is above, Lordship. I have seen, Lordship.
because
2006.
no, this is seniority candidate. That is why.
Lordship.
Now come
Lordship.
come to page
Lordship.
come to the minutes.
Lordship.
See 46, page 46.
Page
of the
46, Lordship.
running page. Come to the minus of their affidavit.
Affidavit copy, Lordship, we have not.
That minus of the
Lordship.
selection board meeting.
Lordship.
17th.
Lordship.
Okay. What they have did, see, if you start it, second page. Board also interviewed the candidates personally to test their eligibility.
Lordship.
The board, however, on the basis of interview, as performed by the candidates concerned, decided to promote so-and-so.
Right.
And this is Srinam Dev Odhikari, UDS supervisory assistant, right?
Right.
Then it may be mentioned that whatever, Iftikhar Azad, he was promoted, so in his post, respondent was 6.
Right.
The post left by Iftikhar Azad is accordingly filled up.
Right.
Promoting so-and-so.
Right.
Respondent was 6.
Right.
Existing UDS supervisories.
Right.
Okay. Now questions come to 7.
Lordship.
Board, however, decided not to consider the promotion of the candidates petitioner
Lordship.
for the time being, after having considered their overall assessment of their eligibility.
Lordship.
To that extent is also okay.
Right.
Now come to it. The promoting candidates are, however, scored higher marks than
Others.
others, meaning thereby respondent number 6 has scored higher marks
Higher.
than the petition
Sure.
in the interview.
Sure.
There are 3 things.
Sure.
One is seniority. It is seniority come merit.
Merit. Lordship.
So merit, they have considered, come to see ACRs.
Lordship.
Board also scrutinized
Right.
Come to clause 2. Scrutinize the service book and ACRs of the candidates for the last year. Okay. That is for the purpose of merit.
Lordship,
If you have to reach a particular benchmark,
Lordship,
if all ACRs are bad, he is bad.
Right.
But if suppose he is good, very good, whatever, minimum benchmark is there.
Right.
I think petitioner has scored the benchmark. That is why.
is in the considered zone.
Second is he is senior.
Right.
Third one is you have to fill a benchmark.
Right.
Suppose 20. 10 is suppose suitable for the purpose, suitability or whatever.
Right.
You can do something, some tweaking can be done.
Right.
10. Now, petitioner is senior otherwise. ACR is okay. In the interview, respondent number 6 has scored 15 marks,
Right.
but petitioner has scored 12 marks. Then the petitioner has to be promoted. That is the law. Just because he has scored better marks, seniority come merit.
Cannot be that.
Had it been merit come seniority?
Then,
Yes.
then
Then
then-
respondent number 6.
then
But it
thing
is
is-
seniority come merit.
then thing is different.
Without any further rider.
Lordship, Lordship.
There are sometimes
Right.
having regard to suitability, having regard to so and so.
Then merit come seniority will.
Then,
Part.
but
Okay,
here
here Lordship,
but-
seniority come merit, Lordship.
we have dictated the facts, but
Lordship.
MS Sharma is not available.
Lordship, Lordship.
Now everything is
Online and
petition is hard in
Lordship.
without my presence. Is it not? Whether she was available
So hard in the first upload, in the
first.
corridor, not inside the room, in the corridor.
Name is reflected or not?
Not her name, but it's in council Guwahati High Court.
Seniority list all along he is above Lordship. Otherwise, Lordship, date of joining, date of promotion is same Lordship.
Same.
Same.
In the original cadre, he was senior.
He was senior in the.
In the gradation list, he was senior.
He was senior. That is the issue. Otherwise,
But this has put the question mark. That is what my niche is.
Lordship, Lordship.
That ACR checked, okay.
Lordship.
Seniority, he was otherwise senior.
Right.
This now, promoting candidate
Right.
are, however, scored higher marks than others.
Lordship. Then it will Lordship.
Then
diluting-
even if he scored higher marks,
then it will diluting the Lordship rules.
rules. Mr.
Hi, Hassan.
I think lead over. Quite tonight. Item number? Okay, let her name be reflected, otherwise it will be difficult.
Possibly her name is not reflected.
But on the other dates, her name is, she appeared.
Yes.
MS Sharma has appeared.
Okay.
All 3 previous dates.
Lordship.
Maybe she has missed the item. Previous 4,
Lordship.
5, 6, 7, 8, 9. Previous 9, 10 dates,
Probably she.
they have appeared with, MS Sharma has appeared
Probably today
without
she-
fail.
today miss out.
So benefit of doubt is to be
Lordship,
given.
Lordship. Whereas Lordship dictate all the facts only Lordship.
Facts are-
findings.
So we have to, Yes, sir. Lest I will forget. Huh? ইমান দিল নাযাওঁ এইটো এইটো হ'ব পাৰে কি আছে এইটো এটা পাৰ্টাৰ থাকিল না এইটো পাৰ্টাৰ টিউজডে
Lordship,
Otherwise, I'll forget.
Lordship, Tuesday I'll not be available. After Tuesday, Monday and Tuesday I'll be out of work.
No, don't make such a prayer now after hearing it. Keep somebody here,
Lordship,
Mr.
I
I. Hassan, learned counsel for the petitioner, and Mr. Yes, Mr.
I'm for
Gugoi.
one lordship. I'm for one lordship.
Learned Mr. Kegoi, learned senior government advocate Assam. For the response number 1
Lordship.
are heard. Hardly. As MS S. Sharma, learned standing counsel, GSC is found absent today on call, list the case on Tuesday. For further hearing. You remind me at 10:30. Right?
Lordship. I'll
And please inform Mr. Hassan, learned counsel for the petitioner, and Mr. Gugoi, so have submitted that they would inform MS Sharma, standing counsel GSC accordingly. The name of MS S. Sharma, standing counsel GSC, be reflected in the respondent side in the counsel. But please keep it as a duty
Lordship, I'll
on your part to inform.
oblige.
Item number 3.
Matter pertains to non-payment of contextual bills. Lordship, if you
Why it has come for orders?
admission, Lordship.
Admission by order?
By order,
By order what?
Lordship, this person is a disabled person. He is facing very hardship because of the non-payment of the payment. So, Lordship, if
Who is
your
the
Lordship
respondent?
turns
PWD.
PWD Council, Mr. Igogo is occupied in court number 6, my lord. It will take some time. He's arguing there.
otherwise, Lordship, it is an admitted.
No, let us see your case.
Your Lordship turns to annexure 8 at page 33, Lordship.
What is your work order?
Lordship, there are several work orders. If your
Let us see.
Lordship turns to page 32 at annexure 7, it's an abstract of all the orders. It has been countersigned by the PWD Jorat. The total amount pertains to 5 lakhs.
No, work order 1992.
Yes, sir. Since 1990.
Commencement date of completion.
Yes.
1993.
Then 1991 is of 3 works are of 95.
1995.
Yes.
1995.
Then 96.
Then 1996. One is 2002. What
Yes.
we are doing in 2023?
Lordship, in the mean.
Yesterday we have dismissed one.
No. This is a different Lordship. Case is different because if your Lordship look into annexure 8 at page 33, this is an admitted amount. If the PWD has admitted this fact,
Pursuit before this, we are not will not be entertaining this kind of issue.
because what happened, Lordship, in 2004,
Recombination of fund, this is hopelessly barred by limitation, 30 years. Floodgates will be open.
what happened, Lordship, this case, the petitioner has met with an accident in the year 2004.
I have seen a
he is a
disability. There is some
a
kind of
physically
disability.
disabled person. Lordship.
Right.
58% disabled.
That yesterday also division makes limitation
But Lordship,
aspect for that one cannot entertain. Yes, petitioner is free to pursue the
Your
matter with the
Lordship,
respondent.
your Lordship,
PWD authorities, that is a different matter.
yes, Lord. Your
But
Lordship
so
is-
far, this kind of petition, because you have made the representation, if they are communicating. That will not extend the period of limitation.
But your
Law
lordship,
is also clear.
your lordship is well
Empathy,
aware.
sympathy, okay, I know, but what kind of, if we go on entertaining this kind of petition, Mr. Counsel,
But if your lordship,
just because, go through the division bench judgment which was provided yesterday, sometime, we will not, Mr. Gogoi is not available since,
but if your lordship is well aware of the Shamsher Ali judgment also.
Tamser Ali is, where is the admission from the chief engineer?
Yes, this is the chief engineer's
Where is?
lordship annexure 8.
You pursue the matter before him.
Sir, this court has already directed, we have also pursued the matter and I think
Where?
if lordship, if in annexure 10, is the order, thereafter,
Then
then,
that is fatal.
then annexure.
Page 37. Page 37.
Yes, Lord.
Writ petition is accordingly stands dismissed on withdrawal.
Yes, Lord.
End of the
Thereafter,
matter.
the petitioner is housed.
Do you know the law? You are arguing it.
Hmm.
You are arguing it. Right? Go through Sarguja transport. Have you heard about it? Have you heard? Have you heard about the Sarguja transport decision? No. This has closed your claim before the court. This has closed the road for you to the court. And this cannot revive your cause of action before the court. Go through it. I'm giving you time.
Yes, Lord. In this case,
It
Lord,
is
what
not
happened,
that
I have
without-
just placed some fact. This same court, before the same court, we have approached again.
Then pursue
Thereafter notices
pursue
were
before the court. Pursue
Lord.
before the said court.
No, Lord.
Pursue before the said court.
Notices were issued, Lord. Because
You want to
remedy-
pursue before the said
No,
court.
no. I have, Lord.
And then, I will not go against the law.
Hmm.
Okay, Mr. Gogoi is not appeal. Your name?
H. Agarwal.
Hmm?
H. Agarwal.
And Chakraborty.
H. Agarwal. Harshit Agarwal.
Okay. On the joint prayer of Mr. H. Agarwal Learned Counsel for the petitioner, Mr.
H. Purva.
H. Borua Learned Counsel, appearing for Mr. B. Gogoi Learned Standing Counsel, PWD. It is the case after everything.
Hello, Blanche.
For hearing item number
So
4.
I have to write. Mr. Pati.
Yes.
There is some difficulty today. I have to write, I have to rush, I have to go something for official language.
Let it come after vacation.
Okay. How many? 2018. Okay, it can be granted after vacation.
My lord, I have no problem. If
No
the
problem,
matter-
then
my
don't
lord,
argue. Don't.
No, my lord, but the fact remains, my lord. Your lordship kindly have a look, my lord, the order passed by learned this court, my lord, whereby, my lord, the management has been directed to, my lord, the stay order that has been granted, my lord, subject to the compliance of the provision of section 17B of the Industrial Dispute Act. Now, 17B says, my lord, during pendency of the case, they should pay, my lord, the back wages that has been awarded by the labor court, my lord, landed court. They didn't pay any single, my lord, penny.
File a contempt. File a contempt. It is passed in the writ petition.
My lord, this honorable court, yes, in some
So-
other case, my lord.
File a contempt petition. Is it not? Court has already directed.
My lord, that was, my lord, precondition that non-compliance of, my lord, the section 17B, my lord, will
So whoever
stand-
not filing contempt petition, it is already order is passed in the writ petition. Is it not?
Yes, ma'am.
Is it not?
Yes.
Then to
I have
enforce,
immediately, my
to
lord,
enforce what is the steps required to be taken
my lord,
on
I
the
have,
part of
yes, I have immediately, my lord, filed representation before the
Opti Bhatti
management.
or the petitioner. and Mr. Bikeshan, Learned Council for the respondent number 1. Mr. M. Chetia, Learned Junior Government Advocate, Assam for the respondent number 2. Present, yes. So when we want Mr. Sain and Bhatti?
Well, they take them up. to
November.
Yeah.
Okay, list the case. Immediately after the ensuing long vacation, as short for vital class for the parties. Immediately after.
But Lordship may kindly fix the date. But otherwise,
After vacation, we don't know. Immediately after.